So who finds out then? Who distributes according to what criteria if you don't have a will? Sulaika?
The court will.
Mm-hmm.
You need to make an application to the court.
So it does not happen automatically.
It's not automatic.
Someone needs to apply to the court.
Yes.
Right.
And the court will give that power to that person.
Right.
Which we call the administrator.
Right.
And then, therefore, they will make the decision on how the assets should be divided.
Right.
Accordingly.
Are there any considerations that they look at when they make that decision?
They do. Usually it is the next to skin sort of a thing. Who is your spouse? Who are your children? Sort of a thing. That will they take into account. Then of course your parents, your siblings and so on, you go down the track. Just to bring all those, the family lined up.
I might just add something interesting, an interesting fact. If you die intestate, they can't find any family members of yours. The assets, the estate, actually goes to the Crown. So the government actually gets to keep all your assets.
Yes.
All right, that's an interesting thing. So is the application process to the courts, is it a complicated thing now? You mentioned that there is a process, and could you just elaborate on that process? How does the court gives the administrator the full power to decide as and when she wants what to do with the problem?
Yes, there could be two things. It could be given the full power to decide, or it could be depending on who is the person who is applying for the administration.
Right.
You could be given a structured or limited powers. You need to distribute the estate, so your powers are to call in the assets, but the distribution has to be on equal basis or to all the beneficiaries.
Oh, I see.
That could
Right,
come forward.
right. If someone is not happy in the circumstances, can someone challenge?
Yes, a person could challenge the will.
That is a will. I was more talking about under the administrative sort of situation, the distribution is not equal and someone is not happy. What do you do? Is that a court process again, or?
It is a court process again. You can challenge.
Right.
Say the distribution is unfair. It shouldn't be. Say for example, if it was equal, it shouldn't be equal. I should get a higher portion because of this reason. I do have a disability. I was the person who was in the house looking after the particular person who has passed away. So therefore, I am entitled to more, and that was the wish of the person who passed away, sort of an argument.
You did raise an interesting point as well. Even if you have a will, can that be challenged?
Of course, yes.
What are the grounds?
Yes. Before 1st of January this year, there was many grounds and many people who had the ability to challenge the will. But from 1st of January this year, that has been limited. So there are new changes introduced, mainly 3 changes.
What are those changes?
Yeah. The first change is who are the person, who are the people who can challenge the will.
Who are the people?
Yes.
So it's been limited in a way to those who are dependent, correct me if I'm wrong, Sulaika, on that person who has passed just before their passing.
So it's like a test. You have to prove the circumstances to go there. It's not as easy or in a way possible as in the past. That's what I understand.
Yes, yes. This change to Victoria has raised lots of lawyers' eyebrows. Particularly the Victorian Law Institute was very objective, and they really opposed the changes, and they really had to fight to make some really amendments what they wanted and they thought would benefit the community.
Why do we think the lawyers or the Law Institute, why do they think that the law is, it seems that they say that it's unreasonable, or?
The unreasonable part comes from before, if you are a child or a stepchild, then you did get an automatic right if you are omitted from the will,
right,
to challenge the will. And now, still the criteria, yes, you have to be a child. They have added stepchildren into it now, but with the eligibility criteria component. So you can't be, when I say child, if you are a child under the age of 18, of course, then you can challenge the will. Or if you are a child between the age of 18 and 25, a full-time student, or a child with a disability. Those three categories get the main challenging power. But any other child, an adult child, has to come through and prove two things: that the person passed away did have the obligation of maintaining and supporting you. Those are two high categories to prove, because the new changes mainly relates to the financial dependency.
So is it limited to financial dependency?
So you have to show that an adult child was financially dependent on the parent to challenge the will.
Right.
As we know nowadays, the adult children, mainly in the Australian community today, are very independent financially. But that doesn't say that they are not dependent on the parents or the parent who passed away. So that emotional connection is ignored. So you're really dependent on the person. You don't know what to do just because you have money, because without that parent, that part is ignored. And that will also, because there's that strict component of if an adult child challenge, first thing you have to show why you claim to be dependent, and why can't you manage yourself and you want something from this estate. The second criteria is just to show that you got a financially and emotional dependency, and you can't, mainly the financial part, that you can't support yourself with what you get, and so therefore you are entitled.
Right, so there are various tests, at least two major tests or hurdles, so to speak, before you are entitled or court makes a decision compared to what was before this year.
Yes.
All right.